One of the more common questions that clients ask us about their criminal case is whether their charge can be dismissed if the law enforcement officer failed to read them their Miranda rights. As a result of TV and the movies, many people are misled to believe that the failure of law enforcement to advise the suspect of their Miranda warnings automatically results in the dismissal of the charge. Unfortunately, that's not the law. In general, police officers are not required to read a suspect his Miranda warnings prior to placing him under arrest. The need for Miranda warnings only comes into play if two requirements are met. First, a person has to be in the custody of law enforcement for Miranda warnings to apply. Custody means an arrest or the equivalent of a formal arrest. So if the police come to your house, put you in handcuffs, and take you to the station, you are more than likely in custody. On the other hand, if the police officer talks to you in the comfort of your own living room or on the side of a road after a motor vehicle stop, you probably are not in custody. Second, Miranda warnings are only required if the police intend to ask you questions. So if the police arrest you, take you into custody, but choose not to ask you any questions about the offense, then there was no need to read you your Miranda warnings. On the other hand, if the police arrest you and then seek to interrogate you about the offense you're accused of, it's at that point that they must then read you your Miranda warnings. If you voluntarily waive your Miranda rights, any statements you make could be used against you in court. However, if the officer doesn't follow this procedure, any statements you make while in custody would be subject to suppression. Keep in mind, if you wisely choose to invoke your Miranda rights and not speak with a law enforcement officer, your choice cannot be later used against you to suggest that you had a guilty conscience or that you had something to hide. There are some cases where the entire body of the state's evidence is based upon admissions that a person made while in custody and while being interrogated. In those limited cases, the failure of law enforcement to advise the suspect of Miranda warnings could result in evidence being suppressed and the charges thereafter being dismissed. We have found that even where other incriminating evidence exists, just excluding our client's statements may lead to a better outcome in their case. If you or a loved one has been charged with a criminal offense, we are lawyers that can help. The attorneys in our office are all former state prosecutors who learn law enforcement tactics from the inside. Call us for a free consultation.